Please rise for the justices of the court. Hear ye, hear ye, hear ye. All persons having business before this appellate division of the Supreme Court, held in and for the Third Judicial Department, the state of New York. Let them draw near, give their attention, and they shall be heard. Today's first case is case number CD 232157, Arrigo versus the Napoli. Please be seated.
Great, thank you. And welcome all to the Appellate Division, Third Department. A few quick things. If you are the primary appellant, you have the right to rebuttal in the Third Department. To exercise that privilege, you must tell me before you begin your remarks that you'd wish to and how much time you want to allocate from the time that's been allotted on the calendar. So do that before you begin your remarks, please, and I'll try to help you keep track of time. All of our proceedings are webcast. We just ask that you be aware and mindful of that in your remarks. And we have reviewed and prepared for the arguments, so be aware of that. You need not discuss the facts in any great detail. We know, and we recommend that you go right to the most important legal points that you wish to bring to our attention, because you're likely to be interrupted with questions. I can't guarantee it, but it happens frequently. So with that said, we are all set. Mr. Macdonald.
Good morning, Your Honor. May I reserve five minutes?
Sure thing. And one other thing, I equalized to the time. I had the request for an increase, and if you don't use it all, it's okay. But I know you had agreed to an increase on the other side. So I just made them equal. So.
I've never had a problem with complete usage of my time.
Good.
So
Well, thank you.
But maybe today will be the first.
Good. Thank you.
Good afternoon. I'm Cameron Macdonald from the Government Justice Center on behalf of the plaintiff, Robert Arrigo, in this matter. The good news is the facts in this case are very straightforward. We don't really need to go over them except for the fact that the legislature passed a salary increase for the governor and the lieutenant governor in 2019 after their terms had started, which is our position that is unconstitutional in that the governor and lieutenant's governor's pay may not be raised during their elected terms, and it has good reasons through the history of this state. I want to start this morning with the error at the Supreme Court on the application of Marin v. Silver to this matter and how that was inaccurate and incorrect, and then move on to why with respect to proper constitutional interpretation in this matter, and then talk about just beyond that the history of compensation in this state, and then address the issues with respect to limitations and other defenses raised by the defendants.
For us, I think you recognize, I understand that the trial court, twice went to the merits, but the AG has asserted that this is a threshold, the statute of limitations is a threshold question that we cannot ignore. And so I just want to suggest that that might be where you need to start, because it's a concern.
Sure, I'm happy to start there. So their their argument is centered on CPLR 2015-4, which is a provision that provides a one-year statute of limitations for recovering a penalty or forfeiture under statute, which the courts have construed to also potentially mean restitution with a claim under Section 123 of the state finance law. The issue here, however, is that there's no action for recovering money. This is purely a declaratory judgment action, wanting the court to declare that the pay raises were unconstitutional and for the comptroller to stop making those payments.
But counsel, I can just interrupt for a moment. You didn't seek restitution in your pleading, but isn't it a necessary consequence if you were successful, that the comptroller would then be in a position to then have a responsibility at least, or the authority to then seek to recover monies already paid? So wouldn't that reality put this within the state finance law provision?
Yes and no. To answer your first part of your question first, it is correct that the comptroller would have the authority and the grounds to go recover those funds. However, the legislature contemplated, when it passed 123, providing a menu of choices for plaintiffs to bring, which includes, the list is, including but not limited to a declaratory judgment, an injunction, or seeking restitution. So the plaintiff can simply say, I want this stopped, and it's up to the responsible party within the government to decide what they're going to do about it when the court declares the law. Now, that's not to say that CPLR 2015-4 doesn't apply to whatever action the controller would want to bring. If the plaintiff prevails here and this raise is declared unconstitutional and the controller directed to stop, then if the controller were to go and to seek restitution, these defendants named herein could, in fact, bring the 1-year statute of limitations.
But I thought your pleading invoked Section 123 of the state finance law to give you basically standing as a taxpayer to challenge this. So isn't that statute in play?
Yes, but I think it's in 123B2, it makes it permissive to add the parties receiving the funds as defendants. So the legislature certainly just contemplated that the taxpayer...
Our prior decision already addressed that, though. We determined they were necessary parties. The governor and lieutenant governor were necessary parties in this case.
To the extent that they might have had arguments that were different on the constitutionality, I would agree with that. I would argue, though, however, that at no point has their pecuniary interest been involved in this, in that there's no action pending to recover funds from them, and they would be free, if the controller were to do anything, to raise the defenses they've raised here in discussing latches, discussing the statute of limitations, and so on. But the taxpayer, under the statute, under the legislature can, maybe ought to and should change it so that it is complete, but it certainly provides the taxpayer the option of only bringing an action to stop the payment. And then if it wants to, it can also add in an action for restitution, which this plaintiff chose not to do.
If we find,
Go ahead. You go ahead.
if we find that it is a 1-year statute of limitations and we don't agree with you, then this case falls under Windy Ridge, correct? Like if it's a 1-year statute of limitations, it's over for you.
I would quibble with whether or not 2015-4 actually applies to something where you're trying to get restitution from someone who's received an improper payment. I think that the decision on that is incorrect because a penalty and a forfeiture are separate legal terms from the concept of restitution.
What I'm saying is if we decide it's a 1-year statute of limitations, obviously you're not going to agree with that. But do you agree that because of the Windy Ridge case, then all of the parties, the whole case is dismissed under Windy Ridge?
I think that would be correct if there was that type of action pending in this case.
So there's no pulling out the original comptroller versus the parties that were added. You don't dispute that.
Correct.
Okay, thank
Under
you.
your interpretation, does the statute 215-4 start to run if this court were to find the legislation unconstitutional, as you urge? Then at that point, relative to the comptroller, the statute starts the 1 year, or would the 1 year have already commenced?
Well, I think in the nature of that statute, there is a penalty or a forfeiture, which means that there's a decision that's been made that the party should be penalized or forfeit some sort of legal right. And so I guess I would argue that it doesn't run until the existence of that penalty or the forfeiture begins. Because if you think about it, 2015-4 provides the Attorney General after some amount of time to pick up that action. And so if it didn't accrue when the penalty or the forfeiture was found to exist, then in this instance, the Attorney General would be out of luck on that 3-year provision. So I guess I'm changing my argument.
Would you further argue that it was a mistake, the omission of these parties was an error, such that bringing up the relation back doctrine? Or do you not?
I mean, I guess in retrospect, I will tell you the reality is that we live in a political world where my client just wanted something to stop, didn't want it to be personal, didn't care for going to sue the existing governor and lieutenant governor for money. It wasn't about that. It was about the principle of the issue. And so my client was happy to get a declaration to stop this practice, to keep it consistent with what had happened for 60 years prior and for 140 years before that, to make sure that there wasn't this sort of hanky-panky going on. The whole structure is to stop the legislature from being able to punish or reward a governor, and this thing spoke for itself in that there were a $25,000 kicker one year and a $25,000 kicker the next year in response to an on-time, timely budget. Well, that's something that the controller decides anyhow, but like a not on-time budget is actually a negotiating tool that the governor can use in the political sphere. So to be able to hold that sword over them with these raises, and the numbers don't sound that big in reality, but it's the idea always was the principle to stop it. And so this whole resolution itself kind of illustrated what they were talking about in 1821, where they didn't want the legislature to be able to hold it over a governor, whether to reward their avarice, I think was in the words of Hamilton, or to punish them unnecessarily.
Can we just, for a minute, turn to the merits and talk about the fixed by law definition that's come out of Delgado and how that affects?
Sure. Our position is that fixed by law, the Constitution is the supreme law of the state, and if it sets out a methodology for doing something, that when the legislature follows that methodology, it is following the law and is fixing it by law. So in the Constitution, it says you must pass a concurrent resolution. That's then fixed by law. The issue in Delgado was the fact that there was an argument that I brought about an unelected committee then being able to establish legislative and officer pay and other state elected officials pay that effectively modified an existing statute. And what the Court of Appeals held was that everything that went up through the passing of the law to get to the point where this committee was appointed to then go do its thing met the requirements of being by law, because there was a statute passed that the governor then passed on. I still disagree with that because it didn't leave the governor an opportunity to veto the raises. That's over.
Right.
I lost. But the point here is that we amend the Constitution, it becomes the law of the state without the governor having a thing to do with it, because it's two concurrent resolutions by separate legislators that are then voted by the people. Bills become laws once passed by the legislature if the governor doesn't act within 10 days during a session. So it can happen without there necessarily being assembly vote, Senate vote, and then a governor's signature.
But Council, here in Article 4, the vehicle for a salary change is a concurrent resolution strictly within the legislative body. And I think Delgado made the distinction that Delgado involved both the legislature and the executive in that process. Here, we have a concurrent resolution. Isn't that a distinction between the two categories, fixed by law and concurrent resolution?
So I would argue that fixed by law under the legislative pay, for instance, meant that a statute needed to be passed because there was no other description of the mechanism to do it. But in this instance, in Article 4, Sections 3 and 6, there is the concurrent resolution mechanism provided by the Constitution, so that when the legislature is following the prescriptions of the Constitution, it is actually following the law and establishing those salaries by law, by following what the Constitution prescribes, just like it is when it passes a law to raise legislative pay or judicial pay by passing a law that goes through the regular process under Article 3.
And we have come into your rebuttal time, but we'll still give you the balance of that. Thank you.
Good afternoon, Your Honors. The merits are fascinating, but there's no reason to reach them because this case is time barred. There is a one-year statute of limitations. We know that from the Egan case. What my opponent says is that because he has opted not to ask for a particular item of relief that is available under Article 7A of the state finance law, somehow the one-year limitations period doesn't apply. Cites no authority for this proposition, but it fails for at least two reasons. I mean, first of all, there is going to be a forfeiture in at least two respects were he to win. First, even just looking at the judicial relief, he wants an injunction. So there's going to be a forfeiture going forward. The salary of the governor and lieutenant governor would go down as a result of the declaration. And the practical reality, as Your Honor pointed out, is that the comptroller would be duty-bound to administratively recover the overpayments from the governor and lieutenant governor, so there would be a forfeiture in that respect. And when the legislature put in place Article 7A of the state finance law, it made a policy decision. And that policy decision was that these actions have to be commenced promptly, and they have to be litigated promptly. That's because they're extremely disruptive. They're disruptive to governmental operations, and they're disruptive to the people who are receiving the funds that are alleged to be illegally paid. I mean, here we have hundreds of thousands of dollars of accrued liability as a result of the unreasonable delay in bringing this action. If you're bringing in action to take away the first pay raise that the governor and the lieutenant governor received in 20 years, I think it should have been perfectly obvious that they were necessary parties. The statute of limitations began to run upon the enactment of the joint resolution. That's the official action that the plaintiff claims renders these payments illegal. They didn't bring the governor and the lieutenant governor until more than 3 years after the joint resolution was passed. Even if you ran the limitations period from January 1st of 2019, when the first pay raise went into effect, or January 1st of 2020, or January 1st of 2021, this action is still untimely because the necessary parties were not brought in until after the statute of limitations expired. There's also latches here because of this unreasonable delay. The governor and lieutenant governor are prejudiced. Had they been brought in right away, they could have done something to protect themselves. They could have put the money in escrow, they could have changed their spending, they could have engaged in financial planning, but no, they were deprived of that opportunity because of this unreasonable 3-year delay in joining them as defendants.
I was surprised.
Oh, no, you
Sorry.
go ahead. No, go ahead.
I was surprised, mine's a peripheral point, but I was surprised at the number of pensioners that you asserted would be adversely affected by a ruling. I think it was you that asserted that there are 1,000 people who are in retirement who would be affected because their final salaries are, above the governor's.
Yes, Your Honor, it's on page 465, 466 of the record. That's latches, but in a unique way, because there's be prejudice to non-parties, members of the public, as a result of a belated declaration of unconstitutionality here. So there's no reason to go anywhere near the merits, but if you do, Delgado basically cinches the case on the merits. I mean,
But the one question I have about the two provisions, right? When we're looking at, and I'm going to get the numbers wrong, right? We're looking at the compensation of state officers. So that's what, Article 8, Section 7. Then we have the Article 4, Sections 3 and 6. When we're looking at those two, I mean, I think that part of the argument is that his argument is that you read them conjoined. You don't read one as more specific or one as more general. How, when we're looking at those, there's a way to read as the sections, it's hard to read which is more general and which is more specific. And I think you argue that the specific provision should apply.
well, you cannot read the two together because there is an irreconcilable conflict in light of the Court of Appeals interpretation of the bylaw provision. Because in Delgado, there was a claim made by Mr. Arijo and Mr. Delgado that the salaries of the Attorney General and the Comptroller, who are subject to Article 13, Section 7, were not fixed by law because there was a statute that empowered an independent body to fix the salaries. The Court of Appeals said that fixed by law was satisfied because in passing the Enabling Act, the governor and the legislature both meaningfully participated in the process.
Right, it's participation by both branches of government is fixed by law.
That's correct. So in other words, law as used in Article 13, Section 7 means a statute. albeit one that can delegate authority to an independent body. That meaningful participation requirement cannot be satisfied here because the governor is excluded from the process of passing a joint resolution. So his salary is not fixed by law.
Right, if I agree with you on that point, right, the fixed by law, what I'm saying is the portion about shall not be increased or diminished during the term for which he shall serve to have been elected or appointed. Can that not be read in conjunction with the joint resolution language? Shall receive for their salaries an annual salary be fixed by joint resolution of the Senate and Assembly?
Well, no, Your Honor, because the no increase or decrease provision is part of the same sentence that says the state officers named in the Constitution's salary shall be fixed by law and cannot be increased or decreased. It's one sentence. So if you cannot meet the fixed by law requirement, it can't apply to the governor.
So Section 4 is the more specific statute.
That's right, because it has a salary fixing mechanism fixed by joint resolution that is incompatible with the fixed by law provision of Article 13, Section 7. And what's misleading is that you look at first blush and you say, well, state officer named in the Constitution, governor's a state officer named in the Constitution. But if you take a step back and look structurally, you have Article 4 governing gubernatorial compensation. You have Article 3 governs legislative compensation. Admittedly, there is an exclusivity provision in there, but it also has a redundant provision. It has fixed by law in Article 3. And you have Article 6 governing judicial compensation. It has a provision that says you can increase compensation, but you can't decrease it. So that can't apply to the judiciary either, because there's an irreconcilable conflict between that provision that you can increase but you can't decrease, and the no increase or decrease provision of Article 13, Section 7.
But in Article 4, we don't have that type of
Right.
irreconcilable. I think what you're arguing, this is definitional. Article 13 speaks to fixed by law. By definition, a concurrent resolution does not qualify as a statute fixed by law.
Exactly, Your Honor. That's why it
But
cannot
you
apply.
can't-
What he's
you
trying.
can't
I'm
see
sorry.
that additional language as, I guess my problem I have with Article 4 is there's nothing about whether it can be increased or diminished.
Yes, and I would acknowledge that if you could view a joint resolution as a law, which you can't, you could then read the two of them together. What my opponent's doing is now, he's trying to adopt the argument that I made in Delgado, but wasn't accepted, which is that law means any controlling authority. And under the Constitution, a joint resolution is the controlling authority. The problem with that is that's not what the Court of Appeals adopted. They adopted this meaningful participation requirement. And now Chief Judge Wilson anticipated this. It's not as if the court was somehow blissfully aware of gubernatorial compensation and adopted a reading of by law that, oops, now the Article 13, Section 7 can't apply to the governor. Wilson contrasted Article 13, Section 7 bylaw provision with a joint resolution and said that the way to explain the disparate treatment is that by law requires meaningful participation of both the governor and the legislature. It does create this issue of if you can raise the salary, you can lower the salary during the term. We provided a number of reasons why the drafters might have thought that having that protection wasn't needed for the governor, who's so powerful that she has the ability to fight back if the legislature gets together in bad faith. You'd have to assume a bad faith joining together of both houses of the legislature. The governor can veto their bills. He can use the Billy puppet. The voters will take it out in the legislature if they acted in bad faith. And historically, whenever there was a no increase or decrease provision applicable to the governor, they put it in the governor's specific article. But again, no reason to go anywhere near this issue because they waited too long. There's too many negative consequences on both the governor and lieutenant governor personally and all the retirees under Tier 6. Thank you, Your Honors.
Rita Glavin for Andrew Cuomo. Unless the justices have a specific question for me, we would rest on our papers and Mr. Palladino's, I think, able argument, which covered all the points in our brief.
Okay, thank you.
I want to start by correcting. I'm not certain I agree that now Chief Judge Wilson discussed Article 13, Section 7 in the context of the Delgado case. He was contrasting the processes in Article. Now I'm losing my articles 4, 3, and
I did it wrong before
and
too, so
6, and they really need to get rid of the Roman numerals. But I'd like to address the general and specific and how all this has worked for all this time. 60 years ago, the commission looked at this and thought they were coming up with an elegant solution to the fact that it was unwieldy to be passing constitutional amendments to change the governor and lieutenant governor's pay. And so what they did was they just simply adjusted what was in Article 13, Section 7 to incorporate the officers. They took out the language addressing the fixed by law for the governor and lieutenant governor, added them, took out other state officers, and then basically concluded in, it's at page 479 of the record, that they were solving the problem. They weren't really changing the rest of it because it's going to keep the prohibitions on outside income and extra income for the lieutenant and governor by making them subject to this section. There's no general and specific or conflict going on here. Article 4, Sections 3 and 6 don't talk about a changing income during terms or whatever. Yes, the legislative article is specific in Section 6 of that. And in the judicial article, it is specific about that, the fact that it just can't be diminished. In here, what you've got is the provisions in Article 4, Sections 3 and 6 can be read perfectly fine together with 13.7 to say you can't raise or lower their salaries within their elected terms, which is consistent with 140 years of history before that and 60 years of history hence.
But
So-
I think their argument is it's fixed by law. I have it in front of me. It's must be fixed by law and shall not increase or diminish during that time. So their argument is it has to be read as one sentence, therefore
And I
it's
would
not
argue,
the same.
and I'll just reinforce my argument, repeat my argument that when you follow a procedure set out by the Constitution, you are fixing it by law. So they specifically follow this procedure set out in Article 4, Section 3 and 6 in the Constitution to pass joint resolutions, so then that it is set by law as far as an action under the Constitution as prescribed by the Constitution. What Justice Wilson was talking about, Judge Wilson was talking about in the terms of Delgado was how there is a law passed, what by law means generally under the Constitution, and typically that's contained in Article 3 and all the provisions in Article 3 for how a bill becomes a law, plus Article 4 and the governor's veto power. So in the combination of those two articles, how a bill becomes a law in this state. Finally, just quickly on respect to the pensioners, the legislature can fix that. They have the ability to do the math to fix their own problems and pass a law to correct for whatever misguided things have happened since they violated the Constitution 6 years ago. And again, if the payments stop, it's up to the controller to decide what to do about what has gone on before. I would argue against him trying to collect them, but that's for him to decide what to do. When it comes to the defenses, latches, reliance, and so on, it kind of is self-defeating for anybody. My colleague talked about the going forward salaries of the governor and lieutenant governor. They're here arguing that the legislature can change it today and stop their salaries now and take them down to $1. That's the position they've taken. So the governor and lieutenant governor can't be saying that I'm relying on a forfeiture of a future right to payment at some salary level, because they're arguing for the fact that the legislature can say, you're passing a budget on time on March 31st, or your salary is going down to $1. That's precisely the type of abuse and problem that the design of this was meant to address. If there's nothing further.
Thank you.
Thank you.
Thank you all. Mr. Demuth, as you approach, I just need to take a minute. Michael, can you, yeah, something is happening here so that I always feel like I'm like gonna flip over. It's like kind of like,
I can't find the thing
There's
to
some
make it.
link. Let me do this. Let me push
no,
that
it's
up.
about the, it's not about that, it's about the chair. So, there's this like thing underneath.
Oh.
Construction crew.
Oh, you know
Brian,
what?
are you coming up? Oh, see, that's right, right. See, I really would like to be able to sit back without thinking I'm gonna fall over.
There's a thing on the right, but I don't know if that's height or if that's back and forth. It's locked.
Let's try that. No,
Let me try it right now.
There's also a circle in the middle.
it's the first day of term, so, you know, we come back to start the March term and we find that the imps have been in and, you know,
Played with our chairs.
played with the
No, mine-
chairs.
I'll catch you if it doesn't.
Yeah, it does. It's because it's not.
Ah, there we go. Thank you, guys. Thank
Now I probably
you.
made this
Thank
too
you.
high,
Sorry, I
whoever
pressed
sits
you
next.
into service, but it's
Yeah.
much more
Whoever sits here next
relaxed
is
now
gonna
for
take
your
the floor.
argument.
But it might be anticlimactic
Oh, you
because
can-
I just wanted to say, I mean, the issue on this appeal is whether Supreme Court.
Oh, did you call the case even yet?
Oh.
Let's,
I'm sorry.
let's back
Sorry
up
about that.
a minute.
chairs.
Next case
Mine
is
was a
case
problem
number
too.
CV 232241, Malinsky versus State of New York.
Yes, so the only issue here is whether the Supreme Court properly exercised its discretion in denying the plaintiff's application for a permanent injunction against the State Department of Transportation. Our argument, of course, as laid out in a brief, is that it did properly exercise that discretion. And since the appellant has submitted, I'd be happy to do so as well, unless the court had any questions.
I actually have a couple of factual
Okay.
questions. So the photographs that I looked at in the record, this white pipe that comes across, I believe, the Valenti property, ends up near the water that runs alongside the road next to the culvert. And
Right.
it looks like the white pipe is dispensing water into that water area that would go under the culvert onto the plaintiff's property. Is that white pipe strictly on Valenti's property, or does any of that white pipe extend onto the state's property?
I believe there was some testimony that it was emptying into the state's right of way, but it was an extension that for the most part went across the Valenti property, which of course was being used. It was being used as an emergency sump pump for one of Mr. Valenti's tenants, and it apparently only operated during heavy rain events. So, I mean, what the evidence shows is that the water discharge, that's separate from, of course, the main argument against the state, which was the fill and what duty the state had. But you know, I think the evidence shows that this was really a claim against Valenti. And one of the reasons why I say that is, first of all, not only did DOT, had nothing to do with installing this pipe. This was a private, for the benefit of a private property. But there's also nothing in the record indicating that the plaintiff ever complained to DOT about it. This happened much later than the complaints of the fill placed by an earlier tenant, Mr. Jacobiucci. This was actually apparently installed in 2021. And in fact, if you look at page 164 of the record, which is plaintiff's deposition testimony, he actually acknowledges that, you know, although he sent letters about the fill, which ended in 2017, he never actually complained to DOT about this white pipe, which was the extension for the sump pump. So our position on that is that this is really a claim that in the Valenti, the action against Valenti is still active because summary judgment was denied. That's really, you know, something for them to just, it really doesn't involve the state. It certainly doesn't establish an extraordinary remedy like permanent injunction.
So along the same factual lines, the question I have with respect to the fill allegedly Valenti or a tenant placed in the area near the culvert, I understand the allegations are that the fill was placed on state land. And if the fill was placed on state land, does that keep the state in this case for any particular reason? Because I think the plaintiff is seeking to have the fill removed to lessen the flow of water through the culvert.
Yes, that's its kind of backup argument. Its main argument, which it's now backed away from, was it had submitted an expert report from Mr. Kurt Bedore, who wanted to significantly reconstruct the drainage with two options. One, an overflow drainage system that would have to cross the property of another neighbor who's not a part of this litigation, would require additional drainage easements. And the second, which is even worse because it would redirect drainage, again with extensive reconstruction, along a road owned by the town of Postikill. Again, not a part of this litigation. So that was their main claim, that this is what we have to, that's why they went so far as to hire an expert. This is what we have to do. Right, now that they've been realizing that even their own expert has candidly admitted that this involves intensive reconstruction with the participation of non-parties, now they say, well, you could just remove the fill. But that doesn't justify injunctive relief either, because even again, an affidavit submitted by that same expert for purposes of opposing our motion.
Is that what you perceive that is sought here, is an affirmative injunction that what was placed there many years ago should now be taken up?
Exactly. It's the way to view it is it's a mandatory injunction. They're saying it's not really the status quo anymore because it's been there for years. That's one of the reasons why they don't need a permanent injunction, because the fill, there was, of course, no allegation that DOT ever placed this fill. The only allegation was that this one tenant, Mr. Iacobucci, placed it for a few years, ending in 2017, and then he moved away, and the plaintiff acknowledged, yeah, there were never any problems with that. So that itself defeats, I think, you have to show imminent harm. You have to show ongoing imminent harm. And if he files his complaint, 5 years later, after there's no longer a problem with the fill, I don't see how that meets. You have to meet all of the requirements. But
mine was more specific. Is the fill actually, did the tenant, the Valenti tenant, place fill onto state land? Or is the fill simply on the Valenti property?
no, it does look like, and there are some photographs and there are some letters that we didn't because we were saying it didn't state a cause of action in any event. It does look like, yes, it was placed in the state's right of way.
In the state's right of way, is that just by easement, or do they actually own the property itself?
That is on the east side of the highway. That is actually,
Just the right of way.
Right, by the right of way. But even if you're not even talking about who placed the fill, and of course it wasn't DOT, the removal, Mr. Bedore has already acknowledged that that would be a good first step. But really what he wants is these incredibly extensive proposals that just simply cannot lend itself to permanent injunction, especially when they involve participation by non-parties.
I recognize the claim still is pending against Valenti, as far as I know, anyway,
Yeah.
for purposes of this appeal, and there would be a remedy against Valenti if successful. Has the state sought any taken affirmative stance with respect to having Valenti remove any fill placed on the state right of way?
I am not aware that anything like that has happened. I just don't know. It's certainly not in the record. I mean, it's not as if the state did nothing. I mean, it's important. This is in the record. It's important to point out that in 2015, they did remove a lot of
Is
fill.
that the time that they did the trench that you're talking about, the 80-foot trench that
Yes.
DOT did?
They did two things. And this was at plaintiff's request. In 2015, they uncovered the culvert pipe that runs under the highway that was actually constructed in the 1960s, and then they dug that trench. So it's not as if they completely turned a blind eye. But in the end, I mean,
What was the purpose of the trench exactly? Why did DOT do the trench in 2015?
I think it was, again, their main duty. There's no special duty on the plaintiff to enforce the highway law for his benefit. So it was to improve drainage flowing under the highway, because I guess it had been impeded at that point. Because that's the way.
Why it had been impeded? Is it Valenti's tenant that was causing this?
No, that's never. I mean, that's always been plaintiff's theory. Plaintiff's theory was that there was a marsh, just like there was a marsh on his property, and the construction plan showed it as a swamp, and it's denoted as wetlands. And for decades, and he bought this property knowing that it was burdened by a permanent drainage easement. But he's saying, well, the problem is there was also a marsh on the east side, and when this fill was placed there by this tenant, that disrupted the balance. I mean, it's really all we have is his say-so that happened.
That's not true, because the photos are compelling. I mean, he's got time-dated photos, and the neighbor also concurs that there was a significant change of his property from what I'm seeing, and not just due to, Hurricane Sandy or one storm event. This looks like there are these full-grown trees that are now inundated with water that clearly had not been in the past. So the problem for us, how much is, and what Judge Lynch is asking, how much could the state still be implicated in this, as opposed to it just being Valenti and the tenant?
Right. Well, it's important to know we don't exactly know why water levels rose. I mean, yes, he has an affidavit from I guess a former person who gets used to own the property. He's saying that much. But again, I mean, he also says that I didn't notice there was a problem until after Hurricane Sandy. He says that as well. And the fact is, this was always a very wet property. It's noted as a swamp in the plans. There was never anything that said that there was a swamp on the east side. In fact, that was pointed out to the plaintiff on page 474 by Mr. Melius, who he had been in correspondence with, saying, look, we're basically, DOT has done nothing wrong. They are operating a culvert under a permanent drainage easement, and it's operated for decades exactly as it's supposed to. By draining water on the highway. Yes, he's upset that apparently water levels are rising, but if he had a problem with that, then maybe he should have challenged the easement. He should have said it exceeded the scope, or he never made that argument. As far as negligence claims, so that leaves him with trying to establish some kind of special duty, that there's a benefit that they have to improve drainage on his property, enforce the highway law just for his personal benefit. And they really can't show that, because everything is working as it's supposed to work. The culvert is bringing water from the east side to the west side. The west side of his property is a natural low drainage point. Even Mr. Berdor established that. That's where the water is supposed to go. That's where it's always gone.
In the reply, Mr. Demuth, and we've actually almost used up your time,
Oh my gosh.
but in the reply, there was the argument that there was not proof that intensive work was required to address the problem. And I heard you say, I just want to make sure I understand the argument correctly. You said that proof of intensive work was plaintiff's own expert who said that to address this, we'd have to do all this intensive work. So you're saying that was sort of almost admittedly, because right.
Not only admittedly, but literally, that word intensive was actually used by Mr. Berdor on page 481 of the record.
So your answer to that question in the reply is plaintiff's own proof revealed that intensive work is required.
Right, and not only that, that's not the only thing that, but also requiring the participation of other parties to an injunction, which would, again, militates against issuing this kind of relief. So I guess that's all I had, unless there were any further questions.
Good, thank you.
Thank you.
Next case is case number CV 240857, matter of Winkler versus New York State Education Department, Office of Professional Discipline.
Good afternoon,
Good
Your Honors.
afternoon.
If it may please the court, Mark Romanowski for the petitioners and appellants. I'm going to keep my comments brief, and I would like to reserve 2 minutes for a rebuttal if necessary.
Thank you.
The issue I want to focus on this afternoon is really whether or not it was appropriate for the lower court to dismiss the petition as a matter of a legal determination when there was really no factual findings at all by the court. We had not gotten into discovery, et cetera. The writ of prohibition is perfectly appropriate when we're taking on challenges of jurisdictional questions, and that's the fundamental issue in that petition, is whether or not the OPD operated within its jurisdiction when it brought those charges. Also, there's questions of whether or not Ms. Winkler and FICA are appropriate parties for the target of some of those charges. These are fundamental jurisdictional questions. The court instead took what I would say is a rather traditional approach and said, well, it's not ripe, let yourself go through the hearing, then you can decide at that point in time whether or not there was some type of errors made.
Let me
Well,
interrupt you real briefly. What's
certainly,
the
Your Honor.
status of the disciplinary hearings? Have they been completed yet?
They have not been completed yet, Your Honor. We're about 12 hearings in to this date, and we're probably at least 5 to 6 more yet. And that leads to my next point, which is that there has been and continues to be a significant injury to my client. She's spent hundreds of thousands of dollars defending these cases and will continue to have to incur costs to move this forward.
Could you touch upon why specifically there isn't jurisdiction?
Certainly. So there's two issues on jurisdictional questions. One is a question of proof, which at a motion to dismiss is, of course, inappropriate, but a question of proof on whether or not the OPD properly consulted with someone from the midwife board.
Didn't they say they did, though?
Well, we have someone that said, I had a note and an attorney affirmation. That's not proof. And I'd point out, Your Honor, it was not presented to the lower court. It was presented to this court, not the lower court. So there's a question there on whether that took place. Certainly, the state could have gotten the officer to submit an affidavit saying, I did X, Y, or Z, or the actual member of the midwife board to say they spoke to the officer and supported this.
But the Office of Professional Discipline states specifically that they bring the charges after consultation with a professional member of the State Board for Midwifery.
Correct. That's my point, Your Honor, is that there's no distinct proof that that actually took place. We have an attorney affirmation submitted with these papers saying, I saw some notes about it.
In other words, you say that could have been alleviated had there been an affidavit from the very person who was consulted.
Sure, and that's the point of why a motion to dismiss when it was inappropriate here. The lower court could have gone and done some fact-finding before just dismissing it out of hand and saying, you need to go through the full process and have an Article 78 after the process is complete. So these are questions I think that are appropriate at the outset, should have been addressed at the outset, instead of my client having to go through now 12 hearings and a significant expense to proceed through that.
What was the second one that you?
So the second issue is related also to a jurisdictional question, which is whether or not Ms. Winkler is properly targeted with respect to at least two of the claims that don't involve Ms. Winkler whatsoever. There were other practitioners in her office. Those practitioners.
It's her office.
It's her office, that's correct.
She owns the LLC.
She owns the LLC, correct. And that goes to another one of those questions, Your Honor, which is the LLC a proper target of OPD? So it's the OPD licenses individuals, and should OPD be targeting FICA and Ms. Winkler when you have actions by people that aren't there anymore?
Aren't these all things, though, that can be corrected on appeal?
Well,
It seems to me that's one of the factors, right? If it can be corrected on appeal, then it's not, then the court was correct in dismissing the petition.
Well, I think that it ignores the injury, Your Honor, which is what we're talking about, and why the writ of prohibition is appropriate for jurisdictional questions, because now we have someone that's been subject to many hearings, extreme expense. Her license has been slowed down because of this pending hearing. All these things have taken place to her. These injuries have been suffered by her as we've gone through the hearing process over the past year.
And these hearings, though, are because of,
Some alleged misconduct by prior practitioners, and some other related issues, yes.
okay, and so when those issues arise, they're supposed to go before a board to investigate.
Absolutely.
So I just don't see how your client is unduly, like she's being targeted in some way. It seems like.
Well, certainly, and you know, the state has tried to, I think, appeal to the sensitivity of this court by raising issues regarding the stillbirths. The stillbirths in particular had nothing to do with Ms. Winkler. She was not the practitioner at the time.
I'm saying that there's allegations are brought forward.
It just
That's
seems,
why it's being investigated.
right, this seems to me to be the normal path that occurs in an administrative proceeding. You're not alleging anything that's out of the ordinary.
Well, in my first argument, I am. So my first argument is there's no clear proof that OPD properly followed the procedures for bringing the claims in the first instance. So that's one
Have
question.
you abandoned the claim with regard to the board being illegally constituted?
I think that's a tough claim, Your Honor.
Yeah,
Yes.
okay.
Yeah. Acknowledged. So that's where I'm getting at, is that we don't have clear proof that that jurisdiction was properly exercised, number one. Number two, that at least with respect to claims that don't involve Ms. Winkler, that those claims shouldn't have been brought against her as well. And we think those are clearly jurisdictional questions and ones that need to be addressed at the outset before subjecting someone to these enforcement proceedings. If you have no further questions, I will leave my 2 minutes to rebuttal. Thank you.
Thank you. Lisa, your mic is. Sorry.
Your Honors, Supreme Court did decide on the merits petitioner's request for a writ of prohibition. Supreme Court acknowledged on page 9 of the record, a writ of prohibition is sparingly granted where an agency is proceeding in the absence of jurisdiction. The court then went on to say, the court finds that OPD was authorized by statute to commence disciplinary proceedings against the petitioners. So contrary to what petitioners are saying now, Supreme Court did address its jurisdictional claims. It simply held that they didn't have any merit, and it did so properly. I just would like to note one thing, two things first, Your Honors. Petitioners said just now that there were questions as to whether the LLC was a proper target of disciplinary charges and as to whether Ms. Winkler was properly charged with actions of her employees. Those weren't in their briefs to this court, so they're not properly before the court now. As far as this argument that there was no consultation or there was no proof of consultation, there is. The professional conduct, the officer who brought the charges said in the notices of hearing that he consulted with a member. And then later, because that person is no longer with the office, a member of state education affirmed in support of respondent's motion to dismiss, so therefore in papers to Supreme Court, not, which I guess petitioner's counsel doesn't acknowledge, but there were papers before Supreme Court saying that yes, these consultations happened. And even if the court thinks there's some kind of flaw in that proof, then the answer is not the relief they seek. They're not, that doesn't entitle them to this court granting them a writ of prohibition. What that means is that it needs to be remanded for respondents to file an answer. So they're not entitled to the relief of a writ of prohibition before this court. Supreme Court properly denied on the merits their request for a writ below, and the statements they're raising now aren't even properly before this court. I understand now that they're abandoning the argument that the board was improperly constituted, so I won't address that. Unless the court has questions, I think that really, this is not a complicated case. The court below decided it properly on the merits, contrary to what they say, and they have not shown that they are entitled to the extraordinary relief of a writ of prohibition. Unless the court has further questions, we will rest on the brief and ask that the decision below be affirmed. Thank you.
Just briefly, Your Honors, I actually do agree with opposing counsel that the appropriate remedy from this court is to remand it back to the lower court for further findings relative to our jurisdictional questions. I will disagree, though, that relative to the claims that were raised in our underlying petition, we raised the claims that I brought before this court today as far as jurisdictional questions over the entities and Ms. Winkler in particular. So those were before the lower court and by extension before this court as part of the record. That's all I have to add, Your Honors. Thank you.
Thank you both.
Next case is case number CV 231895, Williams versus the State of New York.
Good morning, Your Honors. Dan Ellis from Herman Law on behalf of the appellant. May it please the court. So both sides agree here that 205A applies in court of claims actions. And that also in this case, the claimant recommenced his action within the 6 months, but failed to get service within that 6 months. The service on the state did not occur until a week after the deadline. So the only question before the court today is whether in the interest of justice, CPLR 306B and CPLR 2001 apply to extend the time to effectuate service. To start with, it's a basic principle that...
Did you argue 2001 at the trial court?
That I actually don't know if that was briefed at the trial court level, Your Honor.
Okay.
I actually don't have that in front of me. It was briefed during this appellate decision, or during this appellate briefing. But to go off the basic principle that when there's no direct conflict with the Court of Claims Act, that the CPLR applies. And it's plain here that there are no conflicts with the CCA, but with section 306B or 2001. The state points to CCA 10 subsection 6 and the strict timelines for service that's included within those statutes. But as the court knows, the Child Victims Act actually abrogated and amended Section 10 and said that it does not apply in cases involving the CVA. So therefore, there's really no conflict here. The question that really was the crux of the underlying decision was that 205A was jurisdictional. But really where I think the court got it wrong is that it was the original claim filed in the Court of Claims that gave jurisdiction to the Court of Claims. This recommenced action had nothing to do with jurisdiction. In fact, the Court of Claims never lost subject matter jurisdiction when the case was dismissed in the first place. And that's really supported by the Signature Health case and the Hamilton Livery leasing cases.
So, hold on a second. The case was dismissed,
Yes.
so the court doesn't have jurisdiction anymore.
Well, they didn't lose subject matter jurisdiction when the case was dismissed because 205A allows us to refile within that 6-month period.
Right, but the problem is the Court of Claims Act doesn't just say file, it says serve, right?
Yes.
So you didn't do it in that time frame. I guess I don't know how it's not a jurisdictional defect. I'm struggling.
Sure. The main issue is that there's case law from the Second Department that says strict compliance with the CPLR does not confer jurisdiction into the Court of Claims. The jurisdiction itself comes from filing the original claim. The court does not lose subject matter jurisdiction by dismissing the case. We have time, we have 6 months under 205 subsection A to recommence the action.
That's provided you comply with 205, and you didn't here, correct?
That's correct, and that's the next issue in the case, which is that 306B and 2001 allow time to effectuate service in the interest of justice, and that's really what we're arguing
Even when there's a claim
here.
relative, even in the Court of Claims, and there's a allegation here that you're not complying with the Court of Claims Act, Section 11, that requires these things to be timely filed?
Well, we did meet Section 11 by filing the initial claim. That's where it comes from originally. That's where the original jurisdiction comes from when we filed the original suit. And there's no
So
question.
you're saying that's not really applicable because you had met it once already? Is that what you're saying when you filed the initial claim?
That's correct. We met the original claim. There's no statute in conflict in the Court of Claims Act. So then we're going under 205A to recommence the action, which we did within 6 months. We just did not effectuate service within the 6 months.
I don't know how you reconcile it. I mean, the Court of Appeals has held that you have to have strict compliance with the jurisdictional component in Court of Claims. And under that Article 11 there, it does say, like my colleague said, it's not just filing, it's also serving. I just don't see how we get around what the Court of Claims has held in the, I guess it's Kolnacki case and Dreger.
Right. I mean, the issue is the original claim was filed within that time and then dismissed on technical, or on
Yeah,
a.
I know why it was dismissed, yeah, okay. I'm just trying to follow you through, that's all.
Okay.
Is there any support for the argument? I mean, have there ever been any cases where CPLR 306B was applied in the Court of Claims?
No, there hasn't. The only appellate decisions on point come from the Second Department. And that is persuasive argument only, obviously. We'd ask the court to rely on the Marinelli decision, which was a Supreme Court decision that was cited in our brief, which actually did allow for these types of claims to be allowed in the Court of Claims. Excuse me, it goes for the proposition that 306 is allowed to revive 205A claims, but there are no appellate decisions directly on point. So if the court has no further questions, we rely on our briefs. Thank you.
Thank you.
Good afternoon, Your Honors. Frank Brady on behalf of Respondent. The Court of Claims properly denied 306B relief here. First of all, there's no ongoing jurisdiction. The Court of Claims dismissed the action, and once that action is terminated, that's when the 205 starts again. So there's no ongoing jurisdiction, which is why you have to comply with the filing requirements of not only 205, which expressly says that you have to both file and serve, but the Court of Claims Act, which expressly says you both file and serve. There is a case on point in the Second Department with respect to applying 205, 306B in the context of 205. That's a case called Stein. It's 186 83rd. That's cited in our brief. It's not a Court of Claims case. But there, the Second Department said that you can't even apply 306B to 205 in a non-Court of Claims case. So even just in a regular Supreme Court case where you think maybe 306B might come into play.
I guess I'm troubled with the concept why you can't apply it. If you take 205 out of the equation, and it's a normal case where you file your pleading before the statute expires, but you don't come within the time frame, the 90 days, and you seek an extension for permission to do it in the, say, interest of justice component, you can do that. A court can grant that relief.
Are we talking about Supreme Court? Or
Yes,
the
yes.
Court? Okay,
So you
we're
can
not
do
talking
that.
about this case.
You're not talking about, I'm not. But I'm talking in Supreme Court, even when you've missed the deadlines, this court under
306.
306B, I was looking for the right number, under 306B, there is a remedy there to allow a little more time to do the service.
Yeah, I think.
And I guess I'm trying to conceptualize, why wouldn't that same remedy relative to service be available in the Court of Claims?
Well, it's not even available in the Supreme Court, according to the Second Department.
Well, that's,
And that is because
but
of
why
the.
is that?
Well, that is because of the express language of 205A. Your action has been terminated. Your claim has been dismissed. Your cause of action has been dismissed in Supreme Court. And now you're going to avail yourself of the grace period that's afforded by Section 205A. So it asks you to do two things. Specifically, we're not in 304 anymore of the CPLR. It says you have to both file the new action and serve it within the 6-month time frame. So you're invoking 205A. What the Second Department, I believe in Stein, is saying, you have to comply with 205A if you're going to invoke 205A. And 306B 205A is more specific to what's required.
Let me go back to a regular action in Supreme Court,
Yeah.
where you missed the timelines under the statute of limitations. You filed, but you haven't served within the 90-day window to perfect your filing, if you will. 306B is a remedy there.
Because in the first instance, when you've commenced the action by filing it, then the court has jurisdiction and can use 306B to extend your time to serve. But if you're using 205, it's not commenced by filing. It's commenced, according to 205, by filing and service. That's the rationale I think the Second Department is applying. Now you don't even have to buy that here, because we're in the Court of Claims, and we know that in the Court of Claims, if you're going to commence an action, it's both filing and service to invoke the court's jurisdiction. So without doing those two acts, you cannot.
I may miscite this, but I think somewhere in the Court of Claims Act, in Article 9, subsection 9 maybe, says the CPLR does apply in the Court of Claims. So why wouldn't that?
Where they don't conflict, right?
Where they don't conflict.
Where they don't conflict.
So why wouldn't it, 205A, file and serve?
Because the filing requirements in the Court of Claims directly conflict with the filing requirements, the commencement by filing provisions of CPLR 304, I believe it is. Those directly conflict. And in the Court of Claims, those requirements are subject matter jurisdictional. That's why the Supreme Court, in theory, and I'm not talking about Stein at the moment, but that you've commenced the action by filing the claim, by filing the action. I didn't serve it in time. Oh, court can forgive that. But the Court of Claims is, you haven't commenced the action. You haven't invoked this court's subject matter jurisdiction.
And subject matter jurisdiction isn't retained when an action's been dismissed.
No, when you're invoking 205, that 6 months begins to run when the action's terminated. Here, it terminated when they opted not to appeal the court's ruling dismissing the first claim. They went a different path. And the outcome isn't actually particularly tasteful, but it's the way the law works in the Court of Claims and in this action.
But it seems like even if we go the CPLR route, which he's suggesting, if he missed and he gets that second chance, it's almost like a second bite at the apple to remedy, he still didn't remedy because he failed to serve. So
Yeah,
even that rescue provision, he failed to get in under the
He
door.
used the second bite of the apple. He used 205A, except he just didn't fulfill the strict jurisdictional requirements.
there's no
by
interest in-
accomplishing service.
And you're saying we can't get to interested justice because the Court of
There
Claims
isn't,
Act says
no.
it's jurisdictional.
It's a tough case in that way. It's a technical one. I acknowledge that, but it's the state of the law. It's what it is. Is there any other questions?
Can I just ask one? What about the argument that when the CVA came into existence, it removed timeframes or changed timeframes?
It
Does
did.
that,
It did, but with respect to the first action that was ultimately terminated.
but only the first?
But it didn't do away with all time limits on, he's not pursuing, he's pursuing under 205 now. He's not pursuing under that.
The original,
The
right.
Child Victims Act relief.
Okay.
And 2001 cannot be invoked to forgive this failure. It's obviously, it's not just a mistake, omission, or irregularities. It goes to a substantial right of a party. There's no questions? Thank you.
Thank you.
All rise. This court is now adjourned until Tuesday, March 25th, 2025 at 1 p.m.
Dan? You